Hello, welcome to another legal update. We planned to do this legal update now, I think, for a couple weeks. And if people follow the news alerts and follow TST in general, uh, you might think the big topic right now is Iowa, where the GOP gubernatorial campaign has turned into a contest of who can be the more anti-TST candidate than the other one. That's not what we're talking about tonight. I think we'll have to put together another legal update for that and allow that some more time to play out as it's getting more and more ridiculous as they're putting out conflicting or competing press releases, each trying to talk about the variety of ways in which they would disregard the First Amendment to deny us our rights in the public forum. But tonight we're going to talk about the flag we flew in Somersworth, New Hampshire, and why that's important and the precedent that allowed for it, and gives people some kind of sense of where our legal grounding is when we fight these battles and why sometimes people deny us and sometimes they let us in, and why we can fight these battles and have a say at all as to what goes on in the public forum. Why do they ever feel compelled to allow us to fly a flag, put up a display, and why does sometimes they feel emboldened to deny us if they have any legal theory behind it at all? And in the case of the Somersworth flag in New Hampshire, it actually starts with Ten Commandments monuments again, which is a battle we fought, and we have an ongoing litigation process in Arkansas to put up a competing monument alongside a Ten Commandments monument that was placed there as a private donation. And to support the claim that the Ten Commandments monument that went up in Arkansas is allowed to be there, doesn't violate the Establishment Clause that creates a separation between church and state and doesn't allow the government to endorse any particular religion. They often cite Van Orden versus Perry, a decision by the Supreme Court from a case originating in Austin, Texas, where a petitioner filed against Rick Perry, who was then the governor of Texas, wanting the government to take down a Ten Commandments monument that was placed on the public grounds in Austin, placed there by a private entity called the Fraternal Order of Eagles. And this Fraternal Order of Eagles actually colluded with the director, Cecil B. DeMille, upon the release of the film The Ten Commandments, starring Charlton Heston. And as part of their publicity campaign, they dumped a bunch of Ten Commandments monuments all over public grounds. And some of them were made to come down, some of them weren't. Some of them were contested, some of them weren't. The ones that weren't contested are generally still remaining, and there actually isn't an accurate count anywhere that I can find of how many of these were placed by the Fraternal Order of Eagles and how many remain in different areas. One of those was in Somersworth. They emulated the same Ten Commandments monument, the same design construct from Van Orden versus Perry from Texas, and the ones that's in Somersworth, New Hampshire, the same design put forward by the Fraternal Order of Eagles to put in Arkansas. And they did this because they felt they were on solid legal ground because Van Orden versus Perry allowed for the Ten Commandments to stay in Austin. That same year, the same Supreme Court, there was McCreary County versus the ACLU, in which they did take down Ten Commandments and they didn't allow for Ten Commandments to be posted in public schools. And they walked a real fine line in trying to justify the one decision as opposed to the other. And the one that really did the flip was it was a 5-4 majority decision each case, and it was Breyer who flipped in Van Orden versus Perry. And his excuse for allowing for the Ten Commandments monument in Van Orden was that it was already over 40 years old. So he said it had some kind of legacy. And beyond that, most of the arguments were that there was no sign of government preference. There was no religious favoritism in allowing this monument to stay there. So of course, the Satanic Temple offering another monument of religious significance completely guts those arguments. For the one, on the one hand, the Ten Commandments monument in Arkansas didn't have 40-year history; it had just gone up. But also, they couldn't claim that there was no evidence of favoritism because they specifically denied our monument. So the Van Orden versus Perry precedent didn't hold up there, but we're still in litigation with it. They still tried to use it in their favor. Um, Rehnquist, in his majority opinion, noted that there were representations of Moses in the Supreme Court. And he says, in this case, we are faced with a display of the Ten Commandments on government property outside Texas state capitol. Such acknowledgments of the role played by the Ten Commandments in our nation's heritage are common throughout America. We need only look within our own courtroom. Since 1935, Moses has stood holding two tablets that reveal portions of the Ten Commandments written in Hebrew, among other lawgivers in the South Freeze. Representations of the Ten Commandments adorn the metal gates lining the north and south sides of the courtroom, as well as the doors of the courtroom. Moses also sits on the exterior east facade of the building holding the Ten Commandments tablets. What you might have missed in there is that he did specifically say, along with other lawmakers. He didn't note that some of those other lawmakers also had religious significance. And we don't think that the value in that observation is that only those lawmakers of religious significance, from Hammurabi to Confucius and others, uh, should enjoy any kind of public presence in a public forum, but that pluralism is the point. So again, offering Baphomet completely guts these arguments that were put forward through Van Orden versus Perry. Just the same, we didn't think we could fight this battle in New Hampshire, where they have the Ten Commandments monument, because it has been there over the 40 years. We weren't offering another monument, and if we did, we don't know that we would be able to, we would have as stronger grounds anyways as we do in Arkansas, again, having that kind of history. But while Breyer was concerned that if they ruled against the Ten Commandments monument in the case of Van Orden versus Perry, that would open up litigation into all kinds of long-standing displays. Something they didn't think about was something that came up in Somersworth, New Hampshire, which is what happens when it's damaged. Or in the case of Somersworth, New Hampshire, the Ten Commandments monument was vandalized. And then the state, or at least the city or the county, I don't know which, I don't know whose budget it was to come out of. They wanted to, in any case, they wanted to replace it with public funds. And that, raises the question of how appropriate is that? Now they kind of grandfathered this in, and they had the notion was that it was privately donated before, so that was an element of it not being government endorsed. But then somebody destroys it and they're using public funds to replace it. Still don't think it's a strong argument, because they know if they would rule against the Ten Commandments monument, or in the case of the government replacing it, that would give a carte blanche to people to go out and destroy a bunch of other long-standing monuments and insist that the government had no right to replace it. Similar to Breyer being concerned that it would open up the door to litigation, I don't think they thought this through entirely. Another thing I don't think they thought through entirely was the reasonable person standard, where they raised in Van Orden versus Perry, talking about no reasonable observer would think that this was a government endorsement of religion. I think this is disproven by the fact that now we see every manner of theocrat trying to model campaigns off of the Van Orden versus Perry finding, and saying that, they have a right to put up Ten Commandments monuments, and it's obvious that they want to do this for explicitly religious purposes, and that they do think that Ten Commandments monuments on public grounds are an endorsement of their religious point of view. I think this is implicit in the very way they go about campaigning for these things. And often in the background, even though they'll be putting forward a secular case for the presence of the Ten Commandments monument, when they're in the courts, in the background, we find that they're very often also very publicly endorsing bringing the gospel in the public square, bringing Jesus into classrooms, all that kind of thing. And, it was spurious logic, the idea that it had secular importance to begin with in Van Orden versus Perry. They were claiming that the excuse that the Ten Commandments monument was meant to combat juvenile delinquency, while citing no data that would even suggest that the presence of a Ten Commandments monument lowers juvenile delinquency. Makes any sense at all. But that's where we're at. And so, uh, does, despite the feeling that we didn't have any real leverage necessarily to go after the Ten Commandments monument in Somersworth, or at least that it was a less available target for us, a less it wasn't really low-hanging fruit. You know, we'd rather take the ones that are a bit less questionably in our favor before taking on something that might really have an established presence in the law. It isn't necessarily so solidly on our side as it is in Arkansas. They had a public forum for flags directly surrounding the Ten Commandments monument. So Soren Malcontent from our New Hampshire and Vermont chapters and a volunteer with our Satanic Representation Committee spearheaded an effort to fly our flag on the flagpoles outside of New Hampshire, which is something that happened. It flew on October 31st through November 1st, and it was there. And we didn't publicize it as it was going up. We mentioned it after the fact and sent out a press release, and now we're talking about it. And I think there's a value in us doing these things quietly sometimes and showing that they happen and that the law can be followed and that these things can take place without the ground opening up and swallowing people and children being corrupted and running amok and smoking marijuana and then cannibalizing each other is usually the downward spiral I think they predict will take place if we're allowed any public presence at all. So it flew, but then New Hampshire immediately moved to cancel its flag flying policy. And with that, I'll give it over to Soren. I don't know, Soren, if you went to those meetings and you read the actual text of the policy change of the flag policy now, but I'm curious as to how that all went.
Thank you, Lucien. I did not actually attend the council meeting. I missed it. I got the notification about it on a Saturday night, and I was like, okay, I probably got this a week in advance. I went to look at the minutes um, on a Tuesday, and I saw that the meeting had happened the day before. As far as the changing of the text, basically they removed everything that involved the mayor's participation, and they changed any wording that mentioned it being a public forum into it being a forum controlled by the city council. Um, and there was a schedule of flags that they had already approved that could fly on certain dates or at certain times, and that would be going forward the flags that would be displayed on the flagpoles.
Is our flag mentioned at all? And did they mention the possibility of people taking offense to our flag, or was that not at all a factor, at least on paper?
On paper, it was not a factor. There was some discussion in the video of the council meeting. Um, they it was referred to as um, so there would be no more abuse of the flagpole policy. Um, one person one council member actually said, this would prevent strange or oddball groups from flying their flags. That's an almost direct quote. However, there were two council members, one in particular who stated, like, you know, let's just talk about the elephant in the room right now, the fact that we're cutting off this public forum that originally was placed there because of the Ten Commandments monument. Couple of the other counselors, one was like, well, this is historical to the city of Somersworth. It's a part of our history.
So they thought the elephant in the room was the Ten Commandments monument. The elephant in the room wasn't the satanic flag.
No, our flag
Okay.
was never mentioned during the city council meeting. Um, I thought that was kind of on purpose, but those are just my thoughts.
Now, I'm wondering what the lawyers think about even discussion of abuse of the flag policy. Do you think that constitutes a certain abuse of propriety within the city council to discuss a changing of rules premised upon the idea that we might have abused the prior policy?
I think yes. There's a First Circuit precedent that we're using in Boston too. We'll see if it has survived the recent Shurtleff case. And by way of background, Shurtleff is another flagpole case. It seems like it's substantially identical to this same New Hampshire town. Uh,
It's worth saying that Boston too is also a flagpole case, in case people didn't come to the last legal update. We're suing Boston in a similar case where they had a flagpole policy that allowed for privately flown entities or private entities to put up flags on the flagpole outside City Hall for a while. They just straight up said no in regards to us, and now we're suing.
Yeah, I don't want to go too deep into the rabbit hole of what Boston 2 is all about. The operative point is that there's a First Circuit case which says you can't a government cannot shut down a public forum because they don't like the speech taking place within the public forum. It's one of the very few cases that opine on it. Mind you, it's dicta, so we'll see if it holds water. The Shurtleff case uh, opined that there's nothing stopping the city of Boston from changing their flagpole policy. And in context, it seems like it was pretty clearly essentially in retaliation for someone wanting to come in and have equal access to the flagpole, which, as the Shurtleff court rightly found, that's just free speech. Yeah, you have to let literally everyone in if you let literally everyone else in. That's just how it works. So I think it's problematic for this New Hampshire town because, as it stands, that First Circuit case, which I've described, is still binding law. So this notion that, oh, well, we don't like oddball groups coming in here, having their unpopular speech on equal terms as whatever we as government entity decides as non-oddball groups having popular speech. That's just shutting down a forum because you don't like the speech taking place within it.
Both you and Stu are on the Kay versus Thurston case, which is the name of our Arkansas case to put the Baphomet Monument beside the Ten Commandments Monument. Our case became enjoined with uh, two other plaintiff groups, the Freedom from Religion Foundation and the ACLU, and they're both suing to see that the Ten Commandments Monument comes down. We're suing to see that the Baphomet Monument goes up if the Ten Commandments Monument remains. And at this point, we are probably looking to have the Baphomet Monument stay up on the public grounds for as long as the Ten Commandments Monument was there. But somewhere in all this, I've been looking at the Kay versus Thurston case, which has dragged on forever without a ruling, and we have no idea what's going on or when we can expect to hear anything from it. But I see in that case, we've had all this kind of back and forth about whether the Ten Commandments monument can appropriately stay. And then I was looking over Van Orden versus Perry, and Clarence Thomas and his concurrence on that one was arguing against the notion that the Ten Commandments monument was offensive to the petitioner. And he said he need not stop to read it or even look at it, let alone to express support for it or adopt the commandments as guides for his life. The mere presence of the monument along his path involves no coercion and thus does not violate the Establishment Clause. And I can very much see that argument working in our favor because I feel like the argument is that it doesn't matter if you take offense to it, right? And I feel like the only argument against us would be one of offense. But this got me to thinking, what are their arguments for denying us? And did they even offer any? And if Kay versus Thurston goes one way or the other, or if it goes one way, they want to keep the Ten Commandments monument up. Would this be something where we would pursue separate litigation on them having denied the Baphomet monument, or did they? You see what I'm saying? I feel like the whole case, once it got enjoined with the other parties, became whether or not the Ten Commandments monument remains, with the idea that in order to remedy it, our case, it's the question of whether the Baphomet going up balances this out. But I don't remember them offering justification to the court as to why they denied us.
Well,
So go ahead.
there's a couple things at play here. Um, First of all, there's a difference between government speech and freedom of religion. So I think that's the first line of their defense is always going to be, we're not a real religion. Because if they were able to establish that, what that says is now it falls under a free speech issue. If it's a free speech issue, there is a concept of government speech, meaning if it's a government or a quasi-government forum, they can control what viewpoints are shown, because the classic example is they don't want like a KKK flag or a Nazi flag flying, which they're going to equate us with because we're some subversive group. So that's always going to be their first line of defense, but that stops when it's a freedom of religion issue. So I think what they really focus on is that Satanism is not a real religion. That's why it's so important to establish that, because then it takes it out of the free speech context and into the freedom of religion, which is a whole different analysis. As far as the monument being static, that was one of the Van Orden versus Perry issues. Is that, well, if it just sits there, the monument's not screaming at you, it's not preaching to you, it's just sitting there, and no one complained about it for 40 years. That means it's more valid. With and it also brings up the fact that the Establishment Clause has two parts. The first one is you can't endorse a religion. The second part is you can't disparage a religion. And what we find in our cases is they do both. They endorse one religion over another, and they disparage us at the same time. What's interesting about the legal premise that we were able to join that case, it's actually called intervention. We intervened because our argument was, if one side wins or the other, we lose, because either the Ten Commandments monument stands by itself or it gets taken down. Either way, our claim is not addressed because we want it standing up, not in isolation, but next to the Ten Commandments monument. And like you said, Lucien, if the argument is just walking past it can't offend somebody, then that's an argument in favor for our position, right? So I think the issues are kind of layered versus freedom of religion versus government speech. The fact that we don't want our monument in isolation, the whole point of it is pluralism, not to then have ours be the predominant viewpoint or whatever, what have you. The only one that's being shown here. It's like the whole point is pluralism, and I think that's the difference between our arguments and, for instance, the ACLU or the Freedom from Religion Foundation, is they want this stuff removed. They want it to not be promoted. We just don't want to be disparaged, so we want to put ours up next to it. And I think all of these concepts layered are kind of what makes our lawsuits unique.
Well, not to put too fine of a point on it, but our argument as it stands is it is an Establishment Clause violation to have the Ten Commandments monument up. What we want is either, Judge, you are going to find that it's an Establishment Clause violation, which we contend is the case, and therefore the monument has to go down. But what about it's an Equal Protection Clause claim. What about our Equal Protection Clause claim of they shouldn't have told us no? So even if you strike it down, we should still go up for the same number of days, because we're still operatively competing with the shadow of since 2018 that this damn thing's been up. In the mind of the reasonable observer, to use the language of Van Orden, although I don't think that's still binding the way things work anymore after Bremerton, Kennedy versus Bremerton. In the mind of the passerby who goes past this religious monument every day, they've seen this Ten Commandments monument up for, call it 7-8 years now. They need to see the Baphomet monument up for 7-8 years now to understand that these state capitol grounds are pluralistic. On the other hand, if you say it's not an Establishment Clause violation, well, then everything Stu just said carries twice as strong. You have to put us up because otherwise that's why, under Van Orden, the theory goes we have various kinds of monuments of all sorts interspersed all throughout the state capitol grounds. So, what's the issue with one more?
Oh, so Van Orden versus Perry very clearly doesn't apply when they're talking about the justification for putting up the Ten Commandments monument in Arkansas. And at the time we started pressing this lawsuit, it felt that the law was so firmly established on our side that it would be hard to imagine how we could lose. And it's still difficult to imagine, but then you mentioned the case Bremerton, and Bremerton was that case of Coach Kennedy in Seattle area deciding he needed to pray with his football team, high school football team, on the 50-yard line before the games. Some parents or students felt this was coercive. They sued, and I equally thought that was a very strong case that, of course, you can't do this thing, but they ruled in his favor. How does this change the precedent any precedent that's applied towards our case in Kay versus Thurston?
It doesn't.
Oh, I'm sorry. I thought that's what you were suggesting.
No. Kennedy has some dicta to the general effect that reasonable observer standing is just not a thing anymore. You can't be an atheist, for example, see that a government is endorsing a particular religion and say, I'm offended that they're endorsing that religion, therefore I want to sue. I think it's Kennedy. There may have been a different case that speaks to this. I'm pretty sure it's Kennedy, though. So the notion of what does a reasonable observer think about whether or not this is a Establishment Clause violation, essentially, is it governmental preference for a particular religion, or is it a government specifically identifying a different religion saying we don't like you? I think in this day and age, we're just not dealing with that anymore, and that's kind of been on the decline for a good while now. In Scottsdale, there was a very significant case that we relied on very heavily from the Ninth Circuit, which preceded a big Supreme Court case, and they basically said the same thing. So it's north of 10 years. It's well before Kennedy versus Bremerton that the courts have been like uncomfortable with this notion. All that to say, that doesn't mean that TST doesn't have a remedy. It's just that the jurisprudence that supports the remedy isn't under the Establishment Clause. It's from one comma to the right, which is the Free Exercise Clause. So it's basically the same thing.
Outside the legal lesson, Soren, can you tell us anecdotally how this played out on the ground, how you came to be aware of this and how it was executed, the flag raising?
Yes. So I happened to be traveling around my town one day and was stopped in traffic. And I had always seen the two flagpoles there. Um, and I happened to turn to my right to take a look at the flagpoles to see what flags were flying at the time. And that's when I saw the giant Ten Commandments monument. And so I was like, okay, this is really interesting. I need to find out more about this. When I got home, I did some internet searching. I found out that that little island in the city right next to City Hall is called Citizens Place, and that any citizen could fill out a form that was readily available through the city website to petition to have their flag raised on one of the flagpoles. And it was, if you were celebrating a particular anniversary milestone, whatever. For me, with the original policy before they changed it, there was like a 3-step litmus test on who got approved, and you had to your organization or whomever the flag was representative of had to promote benevolence, diversity, and inclusion, or benevolence, tolerance, and inclusion. And I was like, okay, we've got
Perfect.
that. We've got that. And so I immediately I first went to my congregation head and was like, hey, you know, what do you want to do about this? They empowered me to go ahead and do it because I'm the resident. And so I filled out the application. I brought it in. I actually met with the mayor that day when I brought it in, and he read it over. I had originally filed for the entire month of October in recognition and celebration of our holiday, um, Halloween. And at that time, under our first meeting, there was no um, he had no problem with it whatsoever. He mentioned that there was only one other flag in October, which was the naval anniversary flag. And he said, I see no problem in this. I was like, thank you. He knew who TST was. He remembered the all of the things that happened with our holiday display the year prior in Concord. Um, And about a week later, I got an email from him asking for a picture of the flag.
And
And
this is an administrator at the city hall.
this is the mayor.
Oh, this is the mayor
Yes,
directly. Okay.
yes. Asking for a picture of the flag and more information about our organization, as he put it, meaning TST. And I, in kind, supplied him with a picture of the Baphomet and Stripes flag, which was the one that flew. Um, I put a link in my response to the TST FAQ, and I also copied some of the verbiage, which basically puts our mission statement and the tenets to display how we promote benevolence, tolerance, and inclusivity. Um, I went to turn in the flag, and that was when I was informed that he was only going to approve it for Halloween Day that day. And I tried to push back and be like, can I get the week and, the week leading up to Halloween? And I was told that they had other flag submissions, even though the policy said first come, first served basis.
Okay. So after the fact, other flags were supposed to have come in.
Yes.
And did you check to see if there were any other flags flying in that time? They claim that there were other flags.
Um, I I I did not actually check, but I did not see anything different.
Oh, that's okay. It's something we could pursue by Freedom of Information Act request if it is something we want to pursue. But now, of course, other people are inspired to fly flags on public flagpoles in their areas, and I'm wondering, Matt, do you have insight into that? I doubt we're going to connect people directly with the mayor each time.
Well, I hate the lawyer answer depends, but it depends. Shortlift is the case. It's a free speech case that specifically deals with flagpoles. And as a general proposition, harkening back to what Sue talked about, flagpoles are government speech. The way that governments ordinarily uh, uh, engage with the public, such that they're essentially saying, this is what we support, this is what we believe in, what have you, is a flag. So quintessentially, a flag is not something that you can say, I see a flagpole, I want mine up there. In order for us to have a claim that we want our flag up there, you have to have a specific flagpole. Could be a policy, meaning a written document that says if you want your flagpole up, or your flag up on our flagpole, it's first come, first serve, what have you. Um, or it could be a custom, which is every time you walk past this flagpole, sometimes it's the cities, sometimes it's some random schmucks, other times it's some other random schmucks, what have you. So it has to be in either of those two cases, whether there's a written policy or not. It has to be something where the government has specifically and purposely opened up their government property for the purpose of hosting any random schmuck's speech. If they are expressing, or rather exercising control over the flagpole, saying this is our flagpole, we decide who's up there or not, as a general proposition, you don't have a claim. So yeah, I hate the depends question answer, but it really does depend on whether they've done that. Go ahead, Stu.
I'll add to this. I'll add to this a bit because we handled this with the whole public prayer situation. If there's what we call in that context an all-comer system where anyone can apply, there's still rules. The step one to this is get the policy and follow it to the letter. If there's anything you do outside of that policy, they have a legitimate reason to deny you. If the only reason is because who we are, there's a legal claim, and they should fly it otherwise. But I think the biggest mistake people make is they don't follow the rules. If you don't follow the rules, you don't get in. It doesn't matter who we are. So yeah, make sure that you follow that policy exactly as it's written. And if it's not an all-comer system, if it's one of those situations where there's discretion by the individual council members, the mayor, what have you, you're not going to get in. It's just not going to happen. And we don't have much of a legal challenge we found to that.
Did you really get any public response, Soren, or is it something that seemed to just fly past everybody?
The day of, there was no real public response. We had one passerby that he drove by once while we were gathering when I was going to do the invocation. He yelled something unintelligible out of his truck window about Jesus. And then about 20 minutes later, it was like he'd made a full circle around the city. He came back from the same direction, yelling the same thing. And that was it. It went up and came down without a hitch. There was no real outcry, so to speak, until after the press release, and I shared the TST press release in our two-town pages. Other than the changing of the policy that happened at the council level.
Well, at least they allowed for the flag in Somersworth and then changed their policy. I think for added context on our Boston suit right now, what happened in Boston is they had a policy that allowed for flags and even explicitly religious flags because, they flew a Christian flag in Boston. And then we applied to put up our flag, and they said, wait, hang on. And then they changed their policy. And that doesn't fly, and that's the nature of of the lawsuit there. And I don't think we've had any movement on that since our last legal update, have we?
Correct. The reply was filed in or around May or June. Well, wait, there wasn't a reply. So they filed a motion to dismiss. We filed a response. I think our response was May or June. They did not file a reply, and we're just waiting at this point. So it's kind of like getting at that time where it's like, yeah, we expect a decision pretty soon. I expect probably by end of year we will have a decision, whether we're proceeding toward an appeal or just proceeding toward discovery. But we shall see.
Somebody asks, if the Ten Commandments display is legal only because it's been up for 40 years, how are people born after it went up, supposed to exercise their right to oppose a government-endorsed religion? And I don't think you can. And I think that was part of the point of Clarence Thomas's a little tirade there about how taking offense at something you don't have to look at or subscribe to is not really the basis for a claim at all. And I feel like with our case in Arkansas, we're at like 8 years into that case. 10 years will be a quarter of the way to the Ten Commandments monument being grandfathered in. And I think, again, I just kind of feel like it was a ludicrous standard. People look at Breyer's concurrence because Breyer was the one who flipped. Breyer was on the other side when it was McCreary versus the ACLU, in which they called for Ten Commandments to come down. And then Breyer was trying to justify his reversal in Van Orden versus Perry. But otherwise, the majority opinion in Van Orden versus Perry is pretty straightforward. Yeah, Ten Commandments monuments don't violate the Establishment Clause with much less done to justify it. And this is what makes me nervous about these cases and the ability sometimes of the court to just completely reverse themselves, take a different tact entirely, and decide not to follow precedent. And I have real concerns about the current disposition of the Supreme Court.
Valid concerns, but one thing I do want to push back on is this notion that Van Orden had a majority opinion. Sometimes with Supreme Court opinions, you have to play count the justices, and both Van Orden and McCreary fall within that camp. The reason why everyone focuses on Breyer's opinion isn't because he's the guy who flipped, but because he was the deciding vote. So what you had in both of those cases is a 4-1-4 decision, meaning 4 people voted one way, 4 people voted the other way, which means you have a tiebreaker vote who says basically which way is he going. That's the one who decides functionally the majority opinion. That's the one who you have to look to in terms of determining whether or not it's binding precedent. So in both of those cases, Breyer was the one. In the 2 separate cases, 4 of them went one way, 4 of them went the other way. Breyer went one way in one and the other way in the other, and we have to play count the justices in these couple of cases. Sometimes you have to do it otherwise. It's called a plurality opinion, not a majority opinion. The plurality is the one that says, we are the way that essentially we voted the way that the concurring vote goes. But the concurring vote is concurring in judgment, and then they write a separate opinion. So not to put too narrow of a point on it, but Breyer really is for purposes of determining whether or not something is binding law out of, say, Van Orden or McCreary County, Breyer is the only one who has Van Orden. And even then, it's the narrowest possible grounds for that concurrent vote.
Also, I want to point out McCreary, as far as I know, is still good law, right, Matt?
Technically, they're both still good law.
It's just a perfect example of how these people cherry pick both the Bible and the courts, where we still have laws in place, Supreme Court decisions, both all plurality decisions, as most controversial law is created by plurality decisions, where it's really close, a 5-4 vote or what have you. But what bothers me about the situation is that you have these conservatives who are always citing Van Orden, where there's this other case that's also still a good law that says some of these things need to come down. And that's why the context of each one of these disputes is so important, is because it comes down to some very narrow factual issues where there are other religions represented or other viewpoints. How long was it standing? All of these, it's very fact specific of which way it goes. But the fact that they always rely on the one where they win, where there's lots of other cases where they found Establishment Clause violations that are still good law. I really think those are the ones that need to be focused on when it comes to us kind of entering these public forums.
So part of McCreary was the idea of posting 10 Commandments in schoolrooms.
No, that's Stone versus Graham.
Oh, okay. I'm sorry, but the decision was such that that was coercive. That you can't do that. You can't. That kids are faced with this, and then we also have the Mahmoud ruling that says now you can opt children out of things that are coercive, that go against their religious beliefs or their family's teachings of religious belief. And we feel like that would give us grounds to challenge on behalf of members the posting of 10 Commandments in schoolrooms. And there's all kinds of efforts to post the 10 Commandments in schoolrooms now. And honestly, I don't know what's changed to embolden people. And I feel like that's kind of what Stu might have been touching on by asking if McCreary was even considered good law anymore. What emboldens them? Is it just part of the ongoing effort to challenge the laws again and again until they get their way? Or is there something that precipitated this drive to put 10 Commandments in the classrooms that gives them any better basis than before, other than the idea that the Supreme Court is on their side?
Well, one of the issues is, or one of the aspects is, there was this thing, I think they called it Blitzkrieg or something, like this Project Blitz or something.
Blitz.
Yeah, which was, to me, the first time when what they did was they had a concerted effort where politicians that were part, you know, the Heritage, what is it called? The Heritage
Heritage
Foundation. What have you.
Foundation.
They got together and they were going to push these issues simultaneously everywhere so that it was very hard to fight. What that turned into eventually was, I think they call it Project 2025, which is essentially the same thing, where they made this concerted effort where they were going to flood the courts and flood the legislature with all these bills to essentially create a Sharia law, a religious privilege, where Christianity is the only and the best religion. It's the American religion. We want it defined that way. We want it pushed on the populace. They don't care about constitutional law, because to these Christians, especially evangelical right-wing Christians, the ends justify the means. And the means is to violate the Constitution again and again, to the point where it becomes normal, where this is just the way it is. There's no pushback anymore. I guess this is how it's going to be. And they were kind of sneaky about it with Project Blitz, but now it's just, it has become part of the culture war, where they take pride in violating the Constitution. They take pride in their hypocrisy. They take pride in trying to spread their message to a coercive degree. And that's what we've been fighting since before this got to such a fever pitch.
This might sound a little bit ridiculous, but I've noticed it is. But I've noticed this. I get alerts on news that's relevant to us, news that's relevant to Satan and culture and Satanism and satanic panic, things like that. So in my alerts, I'll often get conservative theocratic updates. And what I'm seeing a lot more lately is this language about how it's the government's job to mitigate evil. And I saw this first on something from Blaze Media, from some ridiculous correspondent for that site that was railing against Halloween and other such things, raw satanic panic stuff. So I didn't take it seriously at first. And then we were having this uproar in Iowa where, as I said, the gubernatorial candidates, all they can talk about is how they will contest and combat and deny TST on any requests we make and that kind of thing. And it turns out some of them were also using this language about how it's the government's job to combat evil, things like that. And usually when I see this terminology pop up again and again, it's because they have a broader plan within the context of Project 2025 or whatever they're doing. I saw that previously for many, many years when they started talking heritage and history, ever since, Van Orden versus Perry, I think in 2005 and probably prior to that. They wanted to build this heritage and history argument to say that there wasn't necessarily a religious project behind putting these Ten Commandments up, and that they can serve a secular purpose and combat juvenile delinquency if you don't think too hard about what the Ten Commandments say and how many of them are specifically about worshiping their God. But I wonder if on something as ludicrous as the notion that the government needs to combat evil, if you actually see any type of if you foresee any type of effort into actually trying to codify this idea of entering that kind of subjectivity into the legal framework where the government has some kind of right or authority to make determinations regarding good and evil when determining legal from illegal. And, that kind of distinction might be difficult for a lot of people to make. If something is immoral, why wouldn't it also be illegal? But there's also a lot of subjectivity on the idea of what is moral and immoral when it comes certainly to symbolic gestures, iconography, that kind of thing. If you're going to say that the Satanic Temple's iconography is evil, despite the fact that it's within the parameters of secular law, are you going to give that kind of latitude to any government agencies? And is this kind of ludicrous wording even something we should be concerned about? But if it's not, why does it seem like there's a nationwide effort to introduce it into the discourse?
It's never changed. It's never changed. The satanic panic never ended. It's the conservative, the entire crux of a conservative movement is to create an in-group and an out-group and demonize the out-group. Calling something evil is it's simple. It's easy. You create a national zeitgeist where you demonize immigrants, Satanists, atheists, whatever it is. And then you label that evil, and then you say, it's the same thing the left and the right does, right? Where it's like rights and virtue transcend laws, right? So they're going to say, well, we've now identified the evil through our media, through our talking heads of politicians. You demonize them, and then you eliminate them. And it's just, this has happened in every society since the beginning of society, I think. And it's just weird in America, and I take personal offense to people saying we don't want weirdos or what was it? Weirdos and oddballs or whatever. It's like America was founded on that. To be an oddball in America is patriotism. And the fact that they're trying to make this chicken shit, really homogenous, boring ass culture, and that's the only thing that's allowed to exist, is so asinine to me. It's so un-American, not just unconstitutional, it's un-American. And then to call everyone different than this really homogenous world evil, it's a playbook that's been used by everything that's considered evil in the history of what's considered evil. And it's so funny to me that every single accusation is an admission to these people. But the way that I see it, the satanic panic never ended. It is, now they're going, they used to go after Teenage Mutant Ninja Turtles. Now it's Labubus. It's never stopped. It's the same shit repackaged.
Well, if we had to steelman the arguments for in Kay versus Thurston, again, we're trying to put the Baphomet Monument up where they have placed a Ten Commandments monument, and the ACLU and Freedom from Religion Foundation are fighting to have the Ten Commandments monument taken down. We've been doing this for years. We've been talking about this for years. But then again, we come on here and we're talking about where the law has changed. Bremerton has happened since we filed, in Arkansas. The law has changed. Precedent has changed. The Lemon test no longer stands. That was the three-pronged test they used to refer to. And first, the statute must have a secular legislative purpose. Second, its principal or primary effect must be one that neither advances nor inhibits religion. Finally, the statute must not foster an excessive government entanglement with religion. And the Supreme Court has pretty much said they've thrown out the Lemon test now, and it's made everybody wonder, where they stand with church-state arguments. And I'm wondering if you had to predict, or if you had to come up with a way in which you could both deny the Baphomet Monument and keep the Ten Commandments monument up, what would that ruling look like? Do you have an idea of what would be the justification for that? Or is that still a contortion that's beyond current precedent that would just entirely set new precedent?
The problem to me is ever since they essentially de facto eliminated the Lemon test, every single religious liberty case is its own precedent. It's completely untethered from the stare decisis system. Like it's basically this patchwork of local municipalities deciding what Establishment Clause issues are based on their local courts. And that was exactly why you had the Lemon test, was to make sure that there was some sort of consistency. So when you get rid of one of those, it's not based on anything. It's based on like what's happening in that local region at the time. I don't know. What do you think, Matt?
I've expressed this opinion more than a few times, but just to reiterate it, I think that a large amount of our Establishment Clause jurisprudence comes from an old-timey notion of free exercise built onto atheists. So free exercise is different from Establishment Clause. Establishment Clause protects everyone from a state-imposed religion. Free exercise protects individual religions from being selectively picked on, essentially. So back in the day, in like the early 1900s, when Establishment Clause really started becoming a thing, it was pretty consistently being done by atheists, and essentially they were bootstrapping free exercise clause arguments onto Establishment Clause arguments. What we are seeing, and just to kind of put a bow on it, up until the 1990s, the free exercise clause was kind of consistently being downplayed, culminating in a very significant case called Smith versus Employment Division, which essentially says it's not an establishment clause problem if you, as an individual religion, happens to be not accommodated by a particular generally applicable law. Um, well, that all changed really strongly during COVID, and now we start seeing the exact opposite, which is Mahmoud versus Taylor, that says, yeah, if you don't like your kid hearing whatever gay books or whatever, you're entitled to your religious accommodation, which is the exact opposite of Employment Division versus Smith. So we're seeing an evolution in the law here, such that now it's the establishment clause on the back foot and not free speech, or rather free exercise. All this to say, I personally think that it's easily explainable and understandable. I just think that our arguments have to be following the free exercise examples that we're seeing being done by, for example, ADF and all these other religious outfits that are pushing religious nationalism. Because I really feel very strongly that your everyday American, number one, doesn't really care about seeing, for example, crucifixes in the public square or, religious expressions in the public square, but they also feel very strongly that if there's going to be a crucifix there, then by God, there better be a Buddha and a Star of David and a fucking pentagram as well.
Well, I guess this is kind of where I was going with the idea that of seeing those comments about the government being there to mitigate evil, and Stu's talking about how these religious liberty laws are just it's a patchwork now, and I'm wondering if that's actually part of the plan. Do you think there's the plan is to kind of break down federalism a bit and give local jurisdiction on religious representation, and giving just these partisan hacks the ability to say they prefer one religion over the other, just explicitly giving them the regional authority to do that, and then codifying federally that you have a preferred religion. Do you think that would be the trajectory of it, or do you think that's too long a route and they don't need to go that way?
I think it's the trajectory, and I think it's the goal. I think that's exactly what it is. What they're trying to do, I mean, the when you break down the federal government in a way that they're doing, both administratively, legislatively, and with these types of issues, dissolving the Department of Education. I mean, what one outcome could be, and I don't want to be sky is falling guy, but one outcome that could happen is essentially in certain states where you have those local theocrats in government, they could turn public schools into churches. And I do think that's the aim and the goal, because that's what they perceive that people want, and that's what they perceive, in those regions. That is American history, and a lot of what these issues are a mythological past that doesn't exist. There's the whole concept of the current regime is that there's this mythological American past where everything was better, and the less educated people are about that, the more they believe that, and the more that these people can get their way. So I do think it's the goal to create these basically local fiefdoms that are easily controlled.
Right? I think now everybody wants to be like Soren. There's going to be Soren action figures around, and people want to fly flags where they are locally. So I feel like it's worth reiterating what people should look for and how they go about it if they want to see if flying a flag is a possibility for them, and how to maybe approach that as they do it. I don't know who wants to take that, but I think people are primed to go.
Well, I appreciate that. I feel like back in the day, Michelle Short and I were big time in the boots on the ground with this concept with the public prayer stuff. It's dangerous. It's also very rewarding. This type of action, because you really get to put your money where your mouth is. And thank you to Soren for doing that. For us, that was 10 years ago or something like that. I can't believe it's been that long. But I am so happy to see people are still doing it. People are still excited to do it. They want to take this kind of action, because the more of us that do it, the more that we stay on the map, that you can't, there is going to be resistance to this type of just blatant constitutional violation, that we oddballs are still out there and we still have our flag, and that we're going to fight to fly it. I think it's really important. So yes, keep it up, everybody.
I think the messaging is really important too, because I think a lot of people look at our iconography and think of it as big fuck you to the rest of the general public. And I think we want them to know that whether you identify with us or not, it's important that we're able to do this for your benefit as well. It's not us against everybody else. It's, I think, everybody against the power of an authoritarian government. And when a government can tell you how to believe or how to identify or coerce you one way or another, even if you're in error on these types of things, the government should be directly confronting issues of policy and law, in laws that do not prohibit people from claims of conscience or developing their conscience in whichever way they see fit, so long as it doesn't encroach on other people. And to start prosecuting people or denigrating people or making people second-class citizens based on these things that are not clear-cut, tangible breaches of what we understand to be somebody else's legal rights, privileges, and just fundamental standing, we have a real problem, and we see this problem gaining more legs now. And again, with the Iowa gubernatorial candidates, the whole conversation being about essentially legislating religious expression and people's adherence to religious identity and practice. That's a very dangerous thing. And people need to understand that, and Christians can understand that as well. They should feel every bit as much fear as we do over letting those liberties go, especially considering how sectarian the wide spectrum of Christianity is, and how even recently in U.S. history, Catholics themselves were a denigrated group that couldn't seek public office. How soon they forget. But very much, this kind of regulation of religion is in every way authoritarian. And I think the founders of the nation recognize that, and that's why religious liberty is given such a high status. But it's ill-defined at this point. And of course, our opposition wants to define it in exclusive terms only for them, which completely bastardizes its actual meaning and its purpose, its function, and its place in a functioning democracy. Well, with that said, anybody who's interested in following in Soren's footsteps and taking up that flag, please reach out to us through our website, and perhaps our Satanic Representation Committee can help you with your efforts wherever you are locally. Try to get the information in advance as to whether there really is a public forum where you're at, and who to contact and that kind of thing. And we might be able to help walk you through, given that we have people who have some kind of experience. Thanks, fellas, for coming on. It's always a pleasure chatting. I think we'll be chatting again soon about Iowa, and have a lovely holiday.
Thank you, Lucien.
Bye, everybody.
All right,
Good
thank
night.
you.